Law, corporate and business law. We have covered chapter 1 and chapter 2 was a bit lengthy chapter. Important from examination point of view, probably examiner will test about 10 to 15 marks missed. So let's move towards chapter 3. Chapter 3 is about law of tort. Chapter 3 about law of tort. Law of tort is a type of civil wrong. One person has done something wrong with other person. Other person, innocent party, will be called claimant, and the other party who did something wrong will be called defendant. Mean claimant can claim for anything from defendant. If defendant have done something wrong against claimant. So this is type of civil wrong. Mean not you haven't to follow the laws. No, you did something wrong with the other person. So the other person, innocent party, can claim for damages, will be called a claimant, and you who are the wrongdoer will be called defendant, mean you will be defending the case. So law of tort is a type of civil wrong. It is a breach of legal duty. Mean there was a contract between two persons, and according to a contract, both parties have to do something, but one party didn't perform their promise. So that is called breach of legal duty. Or infringement, mean break of legal rights. In the other party was having a right, but you didn't provided that right, which give rise to claim of damages. And in that case, the innocent party claimant can sue the other party defendant for damages. It's a civil wrong. Mean there was a contract, one party performed their promise, other party didn't perform. So this is what legal breach. As it's breach of legal duty, there is no liability unless law recognizes that duty exists. The claimant have to prove in the court like other party didn't perform his legal duty. If he is failed to prove that other party didn't perform his duty, claimant will not be entitled for any damages. According to law, tort case can be filed within 6 years. Within 6 years, you can file a case. In case of personal injury, period is reduced to 3 years. If there is no personal injury, there is some financial loss, you can file case within 6 years. But if there is personal injury, you can file case within 3 years. A contractual relation does not need to exist for claim of tort to be successful. It is not necessary that there is a contract between both the parties. There is a road accident due to fault of one party. The injured party, innocent party can claim for damages from faulty party. Was there any contract between them before? No. It is not necessary. In case of claim for tort, there is a contract between the parties. So contract is not necessary. For example, claim for personal injury in road accident. If you suffered injury due to road accident, due to fault of other party, you can claim for the injury. Might be you injured for remain in hospital for 3 months. So you can claim for all the hospital expenses as well. So basically, if you are in hospital for 3 months, you lost your income because you were unable to attend your business, you are unable to attend your job. So you cannot recover you cannot claim for that income loss. You can recover for the loss of injury. Loss of injury mean you paid some hospital expenses that you can recover. But if you are in the hospital, you are unable to attend your business, you lost your income, your sales, you are unable to attend your job, you lost salaries. So that loss is too far, mean remote, that you cannot recover. You can recover only direct losses, not indirect, mean too remote. So let's move. Main elements of tort. Following conditions must be met in order to be successful in action for tort. And if a claimant is filing a case against defendant, these conditions must be fulfilled. Number one, there must be an act, mean the other party have performed any wrong act or omission by defendant, or he was contractually liable to perform anything but he didn't perform. In either he performed any act or he didn't perform any act. Didn't perform any act mean he was contractually liable. Mean there was a contract he need to perform, but he didn't perform. Perform any act mean there was no contract, but he did something wrong. So there must be an act or omission of act by the defendant. Number two, which must have directly caused loss to claimant, i.e. not too remote. Mean the loss is direct due to act or omission of act by the defendant. Too remote losses cannot be recovered. And the court must be able to establish legal liability as a result of damage, and court will establish any liability, mean there should be any proof in the court like defendant have done something wrong. So in order to be take a compensation against tort, three conditions must be fulfilled. First, the defendant have act something or omitted to act something. There is a direct loss due to defendant act, and court must be able to establish legal liability. There are so many things that can be covered under law of tort, but mainly we are focusing on tort of negligence. Negligence means the defendant did something that is relating to carelessness. Negligence is breach of legal duty or take care. While driving, you need to take care. You should not hit others. But if you didn't took care and you hit others, so this means there is a legal duty, there is a breach of legal duty to take care, which results in damages to other. And due to your careless behavior, you hit somebody else and they suffered any loss. This means they can claim for damages. Tort of negligence means carelessness. In order for an action in negligence to be succeed, claimant have to prove three things. In case of claim for negligence under law of tort, you can receive damages being a claimant by meeting three conditions. Mean you need to fulfill these three points of view. What are the 3 points of view? And our whole chapter will based on that. Duty of care was owed to him by the defendant. Mean that party have to prove in the court like the defendant have to perform duty of care. Mean he was careless. Defendant breached that duty. Mean defendant act carelessly, or there was a contract and he omitted to act, mean didn't perform. And thirdly, the claimant loss is due to that defendant breach only. If claimant loss not due to defendant breach, due to some other reasons. So for that loss, there will be no claim of damages. In under law of tort or tort of negligence, claimant can claim for damages by fulfilling these three conditions. First, he has to prove duty of care was owed to him by the defendant. Second, defendant has breached the duty. And third, claimant loss suffered due to breach of defendant duty. Mean direct loss is due to defendant wrongdoing, defendant wrong act. And now we need to study the detail of these 3 points, and the whole chapter is based on these 3 points. First, duty of care was owed, breach of duty by the defendant, and the loss suffered as a direct breach of duty. The loss suffered as a direct breach of duty, mean relating to that breach only. So first point, duty of care. There is duty to take reasonable care not to cause foreseeable harm to others. It is your duty. You should not provide harm to others. You should not provide loss to others. It is duty of every normal human being. If you are driving, you should not hit others. If you will hit others, you are providing harm to others.
So can I sue them?
Yes. If there was no precautions written on the medicine, under what circumstances you can take this medicine or who can not take this medicine. If there was no precautions, you can sue the medicine company. This is law of tort. So what is duty of care? There is a duty to take reasonable care, not to cause foreseeable harm to others. And under duty of care, there comes a principle called neighbor principles. Mean your duty is towards your neighbor. Neighbor is not a people living behind your house. Doesn't mean that. What is meant by neighbor? Neighbor is a person of the duty of care towards his neighbor. Who is a neighbor? A person who is affected by or act or affected by our act, mean who is affected by your act, or anyone whom we can reasonably contemplate that he will be affected by our acts. Mean the person who is affected by your act are going to be affected by your act or could be affected by your act, he is called neighbor. This means for those person, your duty of care always oft. So duty of care opt to neighbor. Who is a neighbor? The person who is affected by your act or could be affected by your act are called neighbor, and for against neighbor, your duty of care always opt. If due to wrong act, they suffered any loss, you will be entitled to pay their damages. And for this, we are having a case. Dongyu versus Stevenson. And this case was changed in the principle, and as a result, manufacturers of goods owe a duty of care to ultimate consumer of the product. In all the consumer of your product to whom you owe the duty of care. And this law was defined after this case. So what's the case between Dongyu and Stevenson? So Mrs. Dongyu went to a cafe with a friend. The friend bought her a bottle of ginger beer, which Mrs. Dongyu drank. Miss D went to a cafe with her friend. They bought a ginger beer. They drank over there. She then discovered that there was a decomposed snail in the bottom of a opaque bottle. And there was insect at the bottom of the bottle, dead insect. Miss D found this sight so upsetting that she suffered physical illness. She sued the manufacturer, claiming that they were under a duty to see that such outside bodies, mean insects, did not get into the ginger beer bottles. So who is the claimant? Mrs. D, who is suing the manufacturer of ginger beer, that is Stephenson Company. But court decided there was a duty on behalf of the manufacturer to take reasonable care in the manufacture of their products. Mean they need to take care. If you are selling anything, it shouldn't be infected. So the manufacturer owes a duty to the consumer to take reasonable care to prevent injury. So Stevenson was liable to pay damages to the Mrs. D. And after this case, this neighbor principles was defined. Who can be affected or could be affected in the future by your act are called your neighbor. And your duty is always off towards neighbor. So Lord Atkin means House of Lord, defined those to whom we owe a duty of care in the neighbor principle. You must take reasonable care to avoid act or omission which you ought reasonably foresee would be likely to injure the neighbor. He defined a neighbor as person who are so directly affected by my act that I ought reasonably to have them in contemplation. So duty of care is owed to neighbor. Number two, duty of care is applied to nervous shocks. Is nervous shocks? Mental stress. Nervous shocks mean mental stress. Like if you saw anything and you got some mental stress, so that is called nervous shock. So duty of care is applied to nervous shocks when there is a sufficient proximity. Proximity means nearness, i.e., that shock was suffered by someone within reasonable range of harm. Like you hit while driving, you hit other car, and the people sitting in other car got severe injured. There was bloodshed. And other lady sitting in third car, she just saw that blood and she went into nervous shocks. Third one. The party you hit, they can claim for damages. But the third lady, she can also claim for damages. Your duty is also off to her as well. Due to this, duty of care is applied to nervous shock, mean the people who got mental stress when there is sufficient proximity because they are so near to the accident, they are so near to the event that happened. That shock was suffered by someone within reasonable range of harm. Due to proximity, mean nearness. And we are having a case on this as well. Hill versus Young, 1943. A motorcyclist was killed in a road accident due to his fault, for which he has responsible. Mean he was on the fault, he was in a hurry, he was over speeding, and he killed like himself in a road accident. A pregnant woman who got off a tram near the scene of the accident claimed that when she got to the scene of the accident, she saw blood on the road and as a result suffered shock, nervous shock, which put her into premature labor, which resulted in the loss of her baby. Due to premature labor, she lost her baby due to nervous shock because she saw the blood, dead body over there. So she claimed for damages not from the dead person, the representative of that dead person. She subsequently brought a claim in relation to nervous shock and the resulting loss. That as she was proximity, mean near to the harm, near to the incident, so she can claim for damages because duty of care owed to her as well. So the House of Lords held that motorcyclist did not owe a duty of care to the pregnant woman as she was not deemed to be foreseeable victim. She was not present at the scene of the accident. She arrived after the accident occurred. In Court of Appeal decided case in favor of that lady, but then appeal to House of Lord. House of Lord said no, she was not near to the accident. If she was near to the accident, like sitting in the next car, then she can claim for damages duty of care of to her. If she's coming from somewhere like the accident happened upstairs, she was downstairs on the station of the tram, and due to noise, she went upstairs and saw, and now she's claiming for that. No, she was not in a proximity, in a range. So duty of care was ought regarding neighbor principle and applied to a person who got nervous shock due to proximity mean range of the harm incident. Number three, duty of care is ought to secondary victim as well. Secondary victim means third party. A secondary victim is someone whose personal safety is not threatened, but who suffers a psychiatric injury as a result of a fear of other safety or trauma of witnessing harrowing event. Mean the lady sitting in the next car, that is secondary victim, to whom duty of care also opt. And there is a case as well, White versus Chief Constable of South Warwickshire Police, 1998 case. The claimant were police constable on duty for maintaining law and order during a football match in April 1989 at Willsborough Stadium. There was a football match in Willsborough Stadium, and the policemen were there for maintaining law and order situation. As a result of overcrowding and the consequent stampede, 95 people died and hundreds of others sustained injuries. The policemen on duty, including the claimant, had to tend to the victim for whom many of them suffered post-traumatic stress disorder. They saw blood, they saw injured people, so they got some stress. Four of them were on duty at the stadium, and the fifth one was responsible for stripping bodies and completing casualty forms at a hospital. Resultantly, they claimed compensation for their psychiatric injury from the police department. The House of Lords overruled the decision of the Court of Appeal and rejected the claim. It was established that the claimants were a secondary victim. A secondary victim is someone whose personal safety is not threatened, but who suffers psychiatric injury as a result of either fear for the safety of others or the trauma of witnessing a harrowing event. In order to succeed in their claim, a secondary victim must satisfy three requirements. What are the three requirements? Number one, they must have close ties of love and affection with the person who suffered injury or death in the accident attributable to the negligence. If the people who got injury, who lost their life, were having no love and affection relationship, mean brother, sister, husband, wife with the policeman, so this condition is not fulfilled. Second, they must have been present at the accident or on the scene in its immediate aftermath, so they were there. And third, the psychiatric injury must have been caused by the direct perception of the accident or its immediate aftermath, and this was also fulfilled. So, first condition was not fulfilled, other condition was fulfilled. And not upon receiving in second hand. In this case, the claimant didn't meet the first criteria. And in case of secondary victim, you can claim for damages by meeting three conditions. First, you must be having a love and affection relationship with the injured. Second, you must be present on the event. And third, you got some trauma or psychiatric issue by seeing that harrowing event.
Suppose if a killer is killing a guy and I'm also present here, but he didn't kill me. It is a shocking thing.
Yeah, see, this is nervous shock.
Yeah.
This is nervous shock. Yeah. So, duty of care is off to secondary victim. A secondary victim is a someone whose personal safety is not threatened, but who suffers psychiatric injury as a result of a fear of other safety or trauma of witnessing a harrowing event. In order to be successful in secondary victim claims, following condition must be met. Number one, victim must have close relation with injured or dead person, love and affection relation. They must be present at accident or on the scene in immediate aftermath. And psychiatric injury must have been caused by direct perception of accident or immediate aftermath. So duty of care of to neighbor principle, to nervous shock people, and to secondary victim. But for secondary victim, these three conditions must be fulfilled. So under law of tort, claimant can claim for negligence by fulfilling these three conditions. Duty of care was off. There is a breach of duty, and claimant suffered loss due to breach of duty by the defendant. So first point we are covering duty of care. To whom duty of care was off? Neighbor principal who got nervous shock and secondary victim. Let's move forward. What kind of loss you can claim for? What kind of loss you can claim for? So action could be taken if physical damage was suffered. Mean for physical damage, you can claim damages. Physical loss, you can claim damages. In case of pure economic loss, law does not recognize liability, mean there is no compensation for pure economic loss. There is compensation for consequential economic loss, but not for pure economic loss. What is pure economic loss? Monetary loss, which is unconnected to physical injury to person or damage to other party. Due to accident, you got injured, you admitted to the hospital, you spend hospital bills. So that is relating to that act. But if you were unable to attend your business, you lost some income, you are unable to attend your job, you lost some income. So that is pure economic loss that you cannot recover because that is too remote. Consequential economic loss is recoverable, mean loss connected to physical injury, your medicine bill, that you can recover. And there is a case Spartan Steel and Alloys Limited versus Martin and Company. Spartan Steel and Martin and Company. Spartan Steel and Alloys Limited had a stainless steel factory. I mean, they are having a steel factory, which obtained its electricity by a direct cable from the power station. And Martin and Company, they were the contractor. They were building something on the road or somewhere. And where they were building, their electric wire was passing from that area. So Martin and Company were doing work on the ground with an excavator and negligently damaged that cable through which electricity is passed to steel mill from grid station. As a consequence, the factory was deprived of electricity for 15 hours, which has caused physical damage to the factory furnaces and metal. This is one loss, physical damage to the furnace and metal. Lost profit on the damaged metal. You see, they will not be able to sell that damaged metal because the metal was in process of producing steel. And lost profit on the metal that was not melted during the time the electricity was off. Then they got three losses. First, physical damage. Second, lost profit on that physical damage. And lost profit on the metal that was not melted within those 15 hours. And Spartan Steel claimed all three heads of damages. Which damages they can? First, they can recover. Second is also relating to that first. But third, that is pure economic loss that they cannot recover. First two are consequential. The third is pure economic loss. So what's the court decided? The Court of Appeal held that Spartan Steel could only recover the damages to their furnace. They may have, what's that word? Had to discard the metal they had to discard and the profit lost on the discarded metal. They could not recover the profit lost due to the factory not being operational for 15 hours. The main reasoning for this was that while the damage is to the metal was a physical damage and the lost profit on the metal was directly consequential upon it, the profit loss due to blockout constituted pure economic loss. So for that, they are not entitled to recover. In what kind of losses claimant can recover? Consequential losses they can cover. Pure economic loss they cannot recover. So first point we have covered Out of those three conditions, duty of care was oft. Now we are moving towards second point, breach of duty. So moving towards breach of duty. Claimant have to show that defendant was in breach of his duty, mean he did something wrong, or he has not shown required standard of care. What is the standard of care? Standard of care usually revolves around the concept of reasonable person standard, i.e., whether someone acted with care as a average person would have in those conditions. In under that circumstances, what could be the care level? So that is called standard of care. Due to different circumstances, it could be different. Sometimes you need to show more care, sometimes you need to show less care. If you are dealing with any of the hazardous chemicals, you need to show more care. If you are dealing with any of the chemicals that is not that much dangerous, so you need to show care, but not that much for hazardous. However, degree of cares varies with several factors. Mean how much care you should show, it depends upon certain factors. Seriousness of injury. Degree of care required has to be balanced with the degree of risk. The more risk, more care is required. If you are dealing with dangerous chemicals, more care is required. If you are dealing with less dangerous chemicals, less care is required. If you are dealing with water, even if you don't care, it doesn't matter. So greater risk of injury, the more should be standard of care. Depends upon seriousness of injury. The higher the risk of injury, the more care is required. The lesser the chance of injury, risk of injury, less care is required. But if you haven't care, you haven't showed standard of care, this means there is a breach of duty. And there is a case. Glasgow Corporation versus Taylor. A 7-year-old child died after eating poisonous berries he had picked from a bush in a park controlled by the defendant. So there was a park who was a caring person for the park, defendant, and there was a tree of poisonous berries. One of the child died after eating that poisonous berries. Though the defendant have placed a written board in the park, these cherries are poisonous. But that board can only be read by the above age people. Children might not able to read that. And if you are aware, in your park, children are also coming. You should take some other steps rather than board only. You should keep those cherries out of the children reach. Might be you can put some fences around that tree so that children should not move over there. So the provision of a warning notice was not enough. Standard of care was not enough because there was a high risk of injury from children point of view. So only that warning board was not enough. So the defendant had breached his duty of care to the child by leaving the berries on the bush. Children are of the higher standard of care, and a lower standard can be expected from them. The degree of care to be exercised may be increased if the claimant is more vulnerable, i.e., young, old, or less able-bodied. And this is based on the rule that you must take your victim as you find him. And if there is a place where children, old age people, disabled people are coming, you should perform more standard of care. If able-bodied people are coming over there, adults are coming over there, less standard of care is enough. So standard of care depends upon certain factors, seriousness of injury. The more the risk of injury, more standard of care is required. Age. Children are of the high standard of care because they are more vulnerable. They are more vulnerable. So standard of care depend upon certain factors. Seriousness of injury, age, third one is competency skills. If you are a skilled person, you need to show more care. If you are an unskilled person, less standard of care is required from. Being a skilled person, having expertise in that field, more standard of care is required from you. During operation of a patient, a doctor miss the any of his instrument into the body. In any of the instrument found into the body of a patient after the operation. You are a doctor. How you can do that? So standard of care increases with experience and possession of particular skills. And there is a case. Halley versus London Electricity Board. In order to carry out some repairs, the defendant made a hole in the pavement. They took sufficient precautions to make the area safe for a sighted person. However, the claimant who was blind fell into the hole and sustained an injury which made him deaf as well. It is your duty if you are constructing any hole somewhere during your work, not only you should take reasonable steps for the sighted people, you should take some steps for the other people who cannot see, for blind people as well. So that blind person have filed a case against London Electricity Board. So the court decided the defendant was in breach of his duty of care to pedestrians, walking persons, as it had failed to ensure that the area was safe for all pedestrians. Because everybody is walking from that area. Although it was reasonably safe for sighted person, clearly it was not for blind persons. So the degree of care to be exercised may be increased if the claimant is more vulnerable, i.e., is young, old, or less able-bodied. This is based on the rule that you must take your victim as you find him. You should be aware about that. Not only the person affected by your action, the person who could be affected by your action are called neighbor. So, you, standard of care depends upon seriousness of injury, age, competency skills, and lack of skills. Lack of training is not relevant. Standard of skills expected from trainee driver will be same as applied to normal driver. After hitting car on a road, you cannot say I'm a new driver. No, you must be trained enough. If you are driving, everybody is driving having the same skills. You cannot say I'm lacking the skills, I'm a new driver, I'm not that much experience. Cost and practicability. If cost of safety measures is high, then standard of care is determined after considering the cost benefit analysis. Basically, if you are moving towards a standard of care, you are going to put something as a safety. So you need to bear some cost, but you need to make analysis of cost benefit. Mean the work you are doing is providing more benefit. You need to bear more cost for safety, less benefit, but you need to take some step with less cost. And common practice, if person acts according to common practice of society, standard of care is assumed to be satisfied. However, if common practice itself is negligent, then this rule will not apply. Mean you should take some step for standard of care according to the common practice in the society. And there is one more case, Roy versus Ministry of Health. A doctor administered a spinal injection which had become contaminated as a result of minute cracks in the fields. Fields mean injection, part of injection. So there was some minute crack, and due to that crack, that injection was contaminated, but he didn't saw that crack. As a result of that, the patient was paralyzed. Might be that injection was expired or something like that. So there was no breach of duty since the doctor who had administered the injection had no way of detecting the contamination because he didn't saw that small minute crack. Common practice. Lack of skills, lack of training or the peculiarities of the defendant are not relevant. Therefore, the standard of skill expected from a trainee accountant is the same as that of any reasonable accountant. So duty of breach of duty, you need to focus on standard of care. If you haven't focused on standard of care, there will always be breach of duty. And standard of care depends upon seriousness of injury, age, competency skills, lack of skills, cost and practicability, mean cost benefit analysis, and common practices. And there's another case, Natterchip versus Weston. During our driving lesson, the defendant, who was a learner driver, lost control of the car and caused an accident in which the claimant was injured. And he was taking a training of driving, and during training driving, he hit another car, and in other car the person got injured. The defendant argued that the claimant was well aware of her lack of skills. I was on driving training. I was taking lesson of driving, and that the court should make allowance for her since she could not be expected to drive like an experienced motorist. But this is not the excuse. So the standard of care for a learner driver would be the usual standard applied to drivers. So that of an experienced and skilled drivers. So she was liable to pay damages. And there is another case, Latimer versus AEC Limited. A factory was flooded as a result of heavy rainstorm, and as a result made the floor of the factory very slippery. Due to rain, there is a water on the floor, and the floor is slippery. Meaning employees during work, they can slip and got injured. So the defendant who owned the factory arranged for sawdust to be spread on the floor. The owner of the factory, he arranged some sawdust, he spread over the floor so that employee should not be slipping with it. However, there was insufficient sawdust to cover the whole area. In some area, still left. The claimant slipped and injured himself on the area where there was no sawdust. But as per common practice, the employer, the owner of the factory, did some steps for standard of care. Because it was not possible to cover all the area of factory through sawdust. Obviously, you should look at where is the sawdust, you should move over, walk from there, rather than the area that is separate. So the defendant was not in breach of its duty, as it had taken all the reasonable precautions that would have been expected given the circumstances, common practice, and had eliminated the risk as so far as was practicable. There is another case, Paris versus Stepney, DC. The defendant was employed, the claimant, as a garage mechanic. The defendant employed the claimant as a garage mechanic. This person was appointed as a garage mechanic by this employer, who had lost the sight of one eye during the war. This person already was unable to see through one eye that was damaged in a war. In order to loosen a stiff bolt, he struck it with a hammer. A piece of metal flew off, and because he was not wearing goggles, stuck him in his good eye, in the other eye that was working fine, causing him to become totally blind. Obviously, if you are working such kind of work, you should wear Google. So the court made the point that not wearing glasses was a common practice. If during that work in a garage, people normally do not wear glasses, goggles, if that was a common practice, so then there is no issue. And in itself was not negligent and therefore could normally be used as a defense. However, because of the particular susceptibility of the defendant, the employer should have taken more care and insisted that he wear goggles. For this reason, the employer was negligent because he can guide regarding safety rules, safety principles for his employees. And if he didn't guide it, then he is negligent. Because in a garage, it is normal practice, people do not wear goggles to protect their eyes. Now we are moving towards third point. In case of tort of negligence, claimant can claim for damages by proving three conditions. Number one, duty of care was ought. Number two, breach of duty. And number three, the loss suffered due to breach of duty, not due to any other reason. So duty of care we have covered. To whom your duty of care is off. Breach of duty we have covered. Breach of duty mean the defendant didn't show the standard of care. And standard of care is dependent upon certain factors that we have covered. Now we are moving towards third principle, third condition, loss suffered as a direct breach of duty. Before moving to that, just take 15 minutes break. We'll just cover only chapter 3 today. It's a little technical.
Actually, I'm in the class right now. Sorry. Oh, yeah, Thursday. Yeah, Thursday. Okay, okay, okay. What time? What time? What time? 11 o'clock. Oh, where is the location? Where? What is Oh, okay, okay, okay. Okay. Thank you. Thank you so much. Bye.
So, chapter 3, Law of Tort. Chapter 3, Law of Tort. Tort for negligence. Claimant can claim for damages from defendant by fulfilling three conditions. Duty of care was ought,
Yes.
breach of that duty, and loss suffered due to direct breach of duty. So first two conditions we have covered. Now moving towards third condition, loss caused because of breach of duty. So claimant must demonstrate, mean prove in the court that he has suffered loss or damage as a direct consequence of breach. There is no other reason for his loss. The loss is due to defendant wrongdoing only. This is also but for test. Claimant must establish a causal link between defendant's conduct, misconduct, wrongdoing, and damage which occurred. And he has to prove with the court, this my loss is due to wrong act of defendant. Mean this loss is linked to that wrong act. If the loss is due to some other reason, then defendant will not be liable for that loss. So part A, if damage was caused by someone or something else, there will be no liability on defendant's part. If claimant would have suffered loss regardless of defendant's conduct, then he has not caused loss. The defendant haven't done anything wrong. If defendant prove in the court, I haven't done anything wrong. In that case, claimant will not be able to entitle for damages. And there is a case, Barnett versus Chelsea and Kensington Hospital Management Committee. The claimant, Barnett. Husband, Mr. Barnett, went to hospital complaining of severe stomach pain and vomiting at night. He was seen by a nurse who telephoned the doctor on duty. If there's a patient who is having a severe stomach pain and he is vomiting, the doctor told her to send him home, and contact his general physician in the morning. GP means general physician in the morning. He asked him to go back home and come tomorrow morning and see the general physician. General physician means expert people for a doctor for stomach pain. Mr. Barnett died 5 hours later from arsenic poisoning. And he was suffering through poisoning, and after 5 hours, he went back to his home. He died. So his wife, Barnett, filed a case against the hospital. But court decided. Even if the doctor had examined Mr. Barnett, at the time there was nothing the doctor could have done to save him. Because he was suffering from arsenic poisoning. So therefore, the hospital was not liable as the doctor's failure to examine Mr. Barnett did not cause his death.
Is
This arsenic poisoning is a type of poisoning that cannot be cured.
oh,
That's right. The hospital was not liable, meaning the death of the Mr. Barnett was not due to doctor negligence, that he didn't attended him. It was due to his own fault. So if something happened after the defendant's breach that caused or contributed to the damage, then the defendant's liability will cease at that point. The following losses are normally recoverable. Loss as a result of personal injury, damage to the property, and financial loss directly connected to personal injury mean loss of wages. As discussed earlier, pure financial loss is very rarely recoverable, pure economic loss. Even where the claimant is able to show the loss was suffered as a result of defendant's breach, the court will not allow recovery of that loss if it is considered to be too remote, i.e., must be of type of loss that is reasonably foreseeable. There is another concept called vicarious liability. Vicarious liability. What is vicarious liability? It occurs when one person is held responsible for the negligence of other. When one person held responsible for the negligence of other. If any of the employee did something wrong with the customer,